heard from Brad Simon and from Garrett Schuman. And we do have some questions. We are inviting your questions. All you have to do is use the chat window, and you could offer some comments on what you've just heard. In the meantime, we have some questions here that we're going to ask our panel, and I just want to prepare them for that. The way this is going to work is I'm going to present a question to one of you. You will have a chance to respond to it, and then we're going to throw it over to the other member of the panel and see if they would care to weigh in on it. So assuming that our panel members are ready, let's go with Garrett Schuman, the first question. Garrett, you spoke about a few DOJ policies passed in 2019, but you didn't mention DOJ's new memo regarding ability to pay analysis. How do you believe the ability to pay memo will affect FCPA practitioners?
Yeah, it's a good question, and I thought about addressing it in this presentation. So the question really is about the so-called ability to pay memo, which is basically DOJ guidance published, I believe, fall 2019, which says that after a company agrees to the appropriate dollar figure at DOJ, that they can raise issues associated with their ability to comply with the total obligations, fines, penalties, and otherwise that have accumulated the total amount, right? And this actually, in this memo, DOJ says, we're gonna, when a company raises an issue with the ability to pay criminal fines and penalties, which we otherwise believe are appropriate, we're going to consider, I don't know if it's 6, 8, 10 factors to decide whether or not, it's appropriate to lower the ultimate fines and penalties imposed in order to ensure that the company doesn't go bankrupt, essentially. I think the language they use is they want to avoid threatening the continuing viability of the organization, let's say. And so the memo encourages DOJ to consider, installment schedules, have companies pay over the course of 10, 15, 20 years instead of, in a lump sum right after the resolution is reached. But what the policy really does is, I think it adds on to something that they published in 2018, which I think they've been calling the anti-piling on memo, which basically refers to the fact that more and more jurisdictions and enforcement agencies, even within the United States, are getting in on the action, and they're bringing all sorts of other enforcement actions. So when DOJ says, okay, we're going to reach a $1 billion settlement or DPA or declination or what have you with a company, then the company already is thinking, wow, that's $1 billion here. It could be another 200 million in France. It could be another 100 million in Ethiopia. It could be another 50 million at the SEC, what have you. And the moment they put all that together, they are saying, my goodness, that's a lot of money. We're not sure we're going to be able to survive. So do I think this memo is going to have a huge effect on every case? Absolutely not. Obviously, it only really affects cases where an organization really does have a threat to their ability to survive in light of the extent of the fines and penalties. And that's going to be some massive cases. So, I was involved in the Odebrecht matter in 2016, December 2016, and in that case, there was ability to pay analysis that was discussed. Obviously, it predated this memo, but considered many of the same issues included in the United States sentencing guidelines. And I think the new memo is a step towards transparency in the same way that a lot of the other policies have been. And one thing I should mention, which is different about this memo and maybe somewhat unexpected, is again, it's in a footnote. It's in a footnote. I think it says something like, the criminal division may, in in appropriate circumstances, further reduce fines and penalties based on collateral consequences that don't necessarily threaten the continued viability of the company, right? So even where you aren't at risk of true bankruptcy, if there's really severe potential consequences for a company, you can make this argument, and you have to decide strategically whether it's wise to do so. But now that there's guidance, you at least know which factors you have to argue to the FCPA unit when you go in to make an ability to pay argument. So that's a bit long-winded, but I think, in short, I don't think this is going to affect every case, and you have to really thoughtfully consider the drawbacks of potentially bringing it up. But in general, you can go for it if it's a close call.
Thank you for that, Garrett. Brad Simon, would you like to weigh in on that, or would you like a fresh question?
Well, no. The only point I would like to make is it's not just companies. Let's not forget that DOJ brings cases against individuals, and Hoskins, who we talked about at length, is an individual. Jeffrey Tesler, the British solicitor who I represented, was an individual. And the fines and penalties that the DOJ seeks in FCPA cases can have a devastating effect on individual defendants. So we're not just talking about corporations here.
Okay, I tell you what, thank you for that. And Brad, I have a fresh question for you if you'd like to take it. Do you believe that the recent FCPA penalties and fines are excessive and disproportionate to the offenses charged?
Well, yes, I think it's getting out of hand. When you're looking at penalties of billions of dollars, one has to wonder whether what's behind those numbers. Is it just a motivation to collect as much money for the government as possible, or does it really have a correlate? Does it correlate to the actual offense? And finally, as I posed the question earlier, do these massive fines really have a deterrent effect, or are wealthy multinational companies going to suck it up and pay the fines and go right out there and commit bribery again, as Technique did? So I do think the fines are excessive, and in most cases.
Thank you for that, Brad. And Garrett, we want to give you the same courtesy. Would you like to weigh in on the fines themselves, the penalties? Are they excessive? Are they disproportionate in your view?
Sure. Yeah. Well, I have to be careful, because my wife is a DOJ prosecutor, so I got to be careful before I start criticizing their penalties and fines. But in all seriousness, I think in a lot of these cases they are in fact excessive. But only because, and I think this is more or less what Brad is saying, they're disproportionate, right? If a relatively small bribe is paid, or even if there's a pervasive area of a company, it's pervasive misconduct within a specific area of the company. Ultimately, and you have to remember this especially, Brad has raised some really good points about individuals. But at the end of the day, a lot of these public companies, right, they're public. So the people who are really hurt by big fines and penalties are shareholders. And I'm not, saying, boo-hoo to people who own public securities. That's not what I mean to say. But I do think at the end of the day, you have to recognize it's a company. It is not an individual. So if it's a company and it's an entity, it's not a person you can put behind bars. The people that you're potentially hurting are the people who have jobs with that company and the shareholders. And there's companies, and this was an argument that Odebrecht made, I think, very effectively. As by the way, they are restructuring now in Brazil. I guess they were right about their ability to pay, because they have bankruptcy protection now in Brazil. But what ends up happening is you're going to have to fire tens of thousands of people. You can't pay their salaries anymore. And that you have to consider before you start imposing fines in the billions. So that's more or less my my views. Although I'm happy to debate that with other people, because I don't think it's necessarily 100% clear cut in all circumstances.
All right. Thank you for those points, Garrett. I'm going to go pivot now to a fresh question to you, Garrett. With respect to multi-jurisdictional enforcement of anti-bribery laws, are there any countries or regions you believe are especially likely to ramp up their own investigations in the coming months and years?
All right. Well, I guess two come to mind. One is France. You know, in France, bribery of foreign officials became illegal in 2000. And kind of a fun fact, in 1997, I guess it was, they got rid of tax deductions for bribing foreign officials. You heard that right. If you were a French company, you could take a tax deduction for your bribes paid to foreign officials until 1997. So, you know, they've gotten a taste, I think, from Airbus and some previous matters. I guess they had a case against Total, and they had some others. You know, they haven't had many, but I think, you know, maybe it'll whet their appetite for getting into this space in a way that the UK has seriously jumped in. And then the other is Latin America. And again, I'm not just biased. If you look at the region, it's clear that they've gotten really sick and tired of having corrupt politicians. And you know, there's a list of dozens of current and former, I guess, people who were former or current presidents of Latin American countries who got indicted or impeached or arrested or otherwise. There's, you know, President Kirchner and in Argentina. There's the three presidents of Brazil, Lula, Rousseff, and Temer. There's countless examples throughout the region. And I think they're sick and tired of it. And I think that's what you're seeing a little bit of in Brazil. There's a public desire to hold folks accountable. And I think they're looking to get into this space for a variety of reasons, in particular in that region. Those are my two thoughts.
And thank you for that, Garrett. And we're going to continue that thread with you, Brad. Do you think about countries or regions you believe are especially likely to ramp up their own investigations in the future?
Well, I think we've seen it already in the UK. The SFO, the Serious Fraud Office, has been particularly diligent or trying to make cases in this area, in the anti-bribery area. They passed their anti-bribery law 5-6 years ago, and I think you're going to see them working vigorously to bring these cases, which poses a question: should all these countries be working independently? Isn't there a way somehow that everyone can work together and share resources? It seems like we have so many countries now who have gotten into the act because they see dollar signs and huge penalties and fines. But it seems to me it would be a lot more effective if countries worked more closely with one another.
All right, thank you, Brad. Now let's go to a fresh question to you. Isn't it a fact of life that in certain countries and certain parts of the world, companies that want to obtain contracts will have to pay bribes, and that there's no other way to do business?
Well, I raised that earlier, and unfortunately, I think it's a sad fact of life. We're used to the U.S. with our constitutional checks and balances and our extensive criminal code. But you go to other parts of the world, and I mentioned Nigeria again, where it's a desperately poor country. It's been under rule by dictators for decades, and the people of that country desperately need modernization. And unless there's a way of getting these malfeasors out of office, like the former dictator Abacha, and somehow instituting democratic reforms, it's just a sad fact of life that these despots demand payment and bribes before any technological innovations and progress and contracts to improve the quality of life can be enacted. So it's easy for prosecutors to sit in Washington and say, well, this is very bad, we have to stamp out bribery. But in certain parts of the world, it's not so easy.
Yeah, and I'm just wondering if you would agree with that, Garrett. Do you take a similar view?
Yeah, I take a similar view. I actually think, this is something we didn't discuss, but part of the statutory scheme of the FCPA is that, right, if you have a so-called grease payment, that's okay. In other words, if you are paying someone in a foreign country something in order for them to do something that they already are supposed to be doing, but they're just sort of like a stick in the mud, they're not doing it, and so in order to get something moving, you have paid them. The FCPA allows that and says it's legal under certain very specific conditions. So the DOJ, on the other end, has taken a very, very narrow view of that provision, and because these cases result in settlements overwhelmingly, basically the exception gets swallowed by the rule. And so, right, I think Congress thought when they were passing it, hey, if you can't get anything done in, let's choose Nigeria just to proceed with this hypothetical, in Nigeria without, you need a permit, and you can't get a permit because, you need to pay a bribe, you should be able to pay a grease payment and be able to do some business there. It's bad for everybody if we start, making it impossible for people to do business in let's say, Nigeria. Whereas DOJ has taken a very, very narrow view of that exception. And in some ways, I think that's problematic because it does exactly what Brad is saying. It makes it so that, you can get really in big trouble with U.S. enforcement authorities for paying these bribes. And never in a million years could you have been successful in your business in that jurisdiction, in that particular industry, without having paid it. So it's a bit of a catch-22.
Mm-hmm. All right. Well, thank you for that reply, Garrett. And gentlemen, what we're going to do is we're going to do the fourth and final of the secret words, and then I have one more question for the both of you. And for the attendees, secret word number 4, appeal. A-P-P-E-A-L, appeal, is the fourth and final of today's secret words. So you know the drill. Jot it down. You're getting a survey from us. Fill the words into the survey, submit it, and you will get your continuing education credit. And thank you, everyone, for your attention to these secret words. Okay, final question here. We're going to start out with Brad. Bradley, wouldn't it make more sense to indict the foreign corrupt officials who take and demand the bribe payments?
Yes. I think Garrett mentioned that the statute doesn't, the specific FCPA statute doesn't encompass that in its present form. However, we do see cases such as the Barbados government official that I alluded to, who was prosecuted in the Eastern District of New York. He was alleged to have paid bribes, but he was actually charged under money laundering statutes. So the statute as worded makes it difficult for that to happen. But I certainly agree that if you're going to prosecute the bribe payers, you ought to prosecute the bribe recipients. Part of the problem is when you're looking at bribe recipients who are governmental officials in countries where there's no extradition with the U.S., it's difficult to bring these cases because you're never going to get the body to the United States.
And thank you for that. And again, Garrett, what do you think on that thing? Would it make more sense to just bribe the foreign officials who take and demand the bribe payments?
Yeah, so I think it, in theory, it makes sense. It certainly makes sense as a matter of, let's say, deterrent value. But there's obviously a political issue there, which is, the U.S. government might not be too happy if let's say, Department of State, Department of Defense might not be too happy if we start going into ally countries and indicting their foreign officials. For obvious reasons. It's a political issue. But we could easily, if we were to criminalize the demand side in addition to the supply side, so to speak, we could easily do what we do in other cases where the national defense interests and DOJ, domestic prosecution interests are in conflict, and we could essentially have a mechanism for having DOJ run those issues through our Office of International Affairs, which already deals with these types of issues involving, as Brad alluded to, extradition. So I don't think, just having a statute that criminalizes it would be a problem. You would just need to make sure it has a mechanism for ensuring that there's not an overzealous prosecutor in a U.S. Attorney's Office who brings one of these cases and it's totally against, U.S. interests abroad.